A graphic that appears to quote the Supreme Court of India is being shared on social media platforms with the claim that the apex court has said that no FIRs will be filed against those who shoot people who pelt stones at the army. These posts suggest that the Supreme Court has given the armed forces a free hand to take action against stone pelters. A keyword search for details did not yield credible reports supporting the claim. A visit to the website of the Supreme Court did not yield such confirmation either. During this search, we found news reports from January 2018 that state that the Jammu and Kashmir police had registered an FIR against army personnel in connection with the Shopian firing incident that took place on 27 January 2018. According to these reports, a mob targeted the army's Garhwal unit and pelted stones at their convoy in Ganopora, Shopian district on 27 January 2018. In response, the army opened fire, resulting in the deaths of 2 civilians and injuries to 9 others. The Jammu and Kashmir police registered a case against army personnel from the 10 Garhwal rifles, including Major Aditya Kumar, under sections 302 punishment for murder and 307 attempt to murder of the Ranbir Penal Code, which was the primary criminal law of the erstwhile Indian state of Jammu and Kashmir, introduced in 1932 and named after Maharaja Ranbir Singh. However, it was repealed and replaced by the Indian Penal Code following the abrogation of Article 370 in 2019. According to reports, Major Aditya Kumar's father, Karanveer Singh, filed a petition in the Supreme Court in February 2018 seeking the quashing of the FIR against Major Kumar in connection with the Shopian firing incident. The petition stated that Major Kumar was not present at the scene of the incident and that the army personnel had opened fire solely in self-defense, in accordance with the law and in the discharge of their duties. On 5th March 2018, a Supreme Court bench comprising then Chief Justice Deepak Mishra, Justice D.Y. Chandrachud and Justice A.M. Khanwilkar, while hearing the writ petition filed by Major Kumar's father, put a stay on the FIR and directed that no investigation should proceed against Major Kumar until the next hearing on 24th April 2018. The court also sought responses from both the central and state governments on the matter. During the proceedings, the Supreme Court did not state at any point that registering an FIR against soldiers involved in the shooting of stone pelters was illegal. This stay was later extended. The case remains pending as on 6th April 2025. However, according to Section 6 of the Armed Forces Special Powers Act, prior approval from the central government is mandatory before initiating any legal action against a soldier or officer acting under the powers granted by the Act. In 2016, the Supreme Court had ruled that there would be no blanket immunity for armed forces personnel in cases of alleged unjustified killings, unless it was determined that the deaths had occurred during genuine encounters or insurgency operations. So, while there is an ongoing case in the Supreme Court related to a 2018 incident of armed forces personnel opening fire on civilians following a stone pelting incident, as the apex court has not issued any order that FIRs should not be registered against soldiers who shoot at stone pelters, this post is misleading. Be the smartest person on your family WhatsApp group by becoming a member on our channel and getting first access to the latest fact checks. Hit that join button now.